Welcome to the Supreme Court Podcast. All opinions expressed in this podcast do not reflect the views of the Supreme Court. For clarity, the text of the decision prevails.
It's not easy, but they have really to decide and they have really to work hard for it. Those clearances, the one we need to give when you apply, it's not easy to go from court to police station, to barangay, to NBI, to immigration, to go all those things take you like to go around for a couple of weeks or a month sometimes.
Recognizing the need to alleviate the plight of refugees, the Supreme Court on February 15, 2022 approved Administrative Matter number 21-07-22-SC, or the Rule on Facilitated Naturalization of Refugees and Stateless Persons. This rule governs the procedure for the filing of petitions for naturalization by refugees and stateless persons recognized by the Philippine government. When the rule was introduced, Chief Justice Alexander G. Gesmundo said that it is the only judiciary-led initiative of its kind at the global level, developed pursuant to the 2017 Interagency Agreement on the Protection of Asylum Seekers, Refugees, and Stateless Persons in the Philippines. The Chief Justice also put into focus the provision of the rule that allows an expeditious and inexpensive process for the acquisition of Philippine citizenship by refugees and stateless persons, which is consistent with the aim to streamline court processes to ensure an efficient, fair, and speedy delivery of justice. How has the Philippine judiciary contributed to protecting the rights of refugees and stateless persons? Hi, I'm Attorney Mike Navallo, Supreme Court Chief Communications Officer. It's the 27th of June 2025. On the final part of this two-part episode, we talk about changes to the legal process for naturalization. How did the rule on facilitated naturalization of refugees and stateless persons affect the process of becoming a naturalized Filipino citizen? Joining us again to talk about this topic are Judge Maria Josefina G. Juan-Torres, member of the Supreme Court Special Committee on the Facilitated Naturalization for Refugees and Stateless Individuals, and Attorney Maria Ermina Valdeavilla-Gallardo, head of the Philippines Office of the United Nations High Commissioner for Refugees. But first, let's listen to Mr. Jalal Aboughaula as he shares his experience as a refugee who later became a naturalized Filipino citizen.
Well, the first time I applied, it did not push through. I applied again 2016. Actually, it's quite hard. Honestly speaking, it's not easy. It's a challenge for me. I'm happy that I pushed through with the challenge, and in the end, I'm successful having my Philippine citizen. And it's my dream long time ago to have a Filipino passport, a Filipino citizen, to become a Filipino citizen. And I like to tell other refugees, it's not easy, but they have really to decide and they have really to work hard for it. Those clearances, the one we need to give when you apply, it's not easy to go from court to police station, to barangay, to NBI, to immigration, to go all those things take you like to go around for a couple of weeks or a month sometimes. Going to the court, it's a kind of challenging. At the same time, for me, it's a new experience to go to court. It was my first time in my life to go to a courtroom. It's a little bit scary to stand up in front of a judge, waiting for that life-changing decision. I'm now 58 years old, and the first time in my life to hold a real passport. I've been holding a travel document, an Egyptian travel document for the Palestinian refugees since I was born. I never hold a passport. This time, at 58 years old, now I am very happy, proud, and grateful for the Philippine government and everybody in the all agencies that helped me to become a refugee and become a Filipino citizenship. I would like to say thank you very much from the bottom of my heart. Thank you very much.
So, and we just listened, Judge Joy, to Mr. Aboughaula, and he talked about the difficulty of acquiring naturalization, or at least becoming a naturalized Filipino citizen here in the Philippines. Has that changed now? Because we know, as you mentioned earlier, there's now the rule on facilitated naturalization of refugees and stateless persons. Did this make the whole process easier for refugees seeking to become naturalized Filipinos?
Thank you, Attorney Mike. I would like to think so, yes. Although for now, as statistics would show, figures would show, there are only two who have more or less benefited from the rule on facilitated naturalization for refugees and stateless persons. But let me just give you a history how it all started, why the Supreme Court came out rather with this rule on facilitated naturalization for refugees and stateless persons. We go back to the Carbasi ruling of the Supreme Court. And for that, I would like to give the floor first to Attorney Iya for the history of a brief background on the Carbasi case.
Right.
So I think before I jump to the Carbasi case, it's important to note that this even started through the advocacy of my predecessors. As early as, I've read some notes as early as 2000s, when the academe and UNHCR worked together to understand what are the gaps and challenges that would allow refugees to be recognized or naturalized in the country. And there were participative consultations with refugees at the time, as well as with private counsels who have been representing some of the refugees in the naturalization cases, as well as the Office of the Solicitor General. Because as the official counsel of the state, they would always have that responsibility to ensure that people who will be given Philippine citizenship are truly deserving and qualified. So that was that long journey of advocacy. And then we met with one of these refugees, Mr. Kamran Carbasi, whose brother was already a refugee at that time. And he had a pending naturalization case as well that was not moving. And they came from the same circumstances in life. Their grounds are the same. They live in the same area. They have the same qualifications. So he was wondering, why is it that my case is not moving and my brother is already a Filipino? And so we had to understand, and again, series of advocacies with the judiciary, with the Office of the Solicitor General. And we had to sit down with the private lawyer of Mr. Carbasi to explain to him that there are certain provisions in the convention that would be favorable to his client, to Mr. Kamran, as a refugee. So that was it. I will no longer go to the specifics, but that was a very memorable experience for me. I was a very young lawyer, as new in UNHCR, I think less than 5 years. And at that time, it was new to me, right? No, it's not something that you discuss in law school. It's not something that you're exposed to. So it's a new experience. And we tested using certain arguments from the point of view of not having to have a lucrative profession, but having a sufficient income not to be a burden to the state. That's an argument. Being able to faithfully comply with the tax requirements of the state. So it was a memorable journey, and I believe in, and have to be honest on this, part of my work is also to advocate with my husband, who at the time was also working for the judiciary. And I had to ask him, is this possible for the Philippines to tick this box and ensure that refugees would be able to have a facilitated way of being naturalized? Because some of these requirements are impossible to be met by refugees.
Right.
And the rest is history, right, Judge Joy?
So
Right.
the UNHCR did play a role in terms of crafting and fine-tuning this rule on facilitated naturalization, Attorney Iya?
Yes, that's right. Of course, the role of the judiciaries is very important, and working as UNHCR with the judiciary is an important step in order to get there. Of course, it can be complemented by a legislation, but again, you have a legislation there. It's just that the rules of procedure need to be reevaluated in order to make it easier for refugees to be able to take a chance and apply as a Filipino citizen eventually.
And from the side of the judiciary, Judge Joy, talk to us about the whole evolution of this rule, how it came to be, and perhaps maybe a discussion on the salient provisions of the rule on facilitated naturalization.
Thank you, Attorney Mike. First, before the rule on facilitated naturalization was promulgated, judicial naturalization would fall under Commonwealth Act 473. And the qualifications actually there for that would mean naturalization for all persons. It does not make a distinction whether you're a refugee, or a stateless person, but any person, an asylum seeker or a foreigner, can apply for judicial naturalization under CA 473. But the qualifications, if you will look at CA 473, which is already an obsolete law, and it really has to be amended in terms of some of its provisions, clearly, especially as mentioned by Attorney Iya, some of those qualifications, like, for example, lucrative income. A refugee, given the circumstances of a refugee or stateless person, will definitely not be able to comply with that qualification. So these are just some of the main points. And then there is also the cost of publication. When you talk about publication requirements, like for now, the going rate would be 50,000 to 1,000 pesos. 50,000 rather, 50,000 to 100,000 pesos.
Right.
A refugee or a stateless person will not have that amount just to be able to pay for the cost of publication.
Right.
And that's a jurisdictional requirement under CA 473. So these are some of the challenges or obstacles that were discussed in the Carbasi case. But what happened here in the Carbasi case is that eventually the Supreme Court looked at it from a more liberal perspective. In essence, the ruling of the Supreme Court is that given the circumstances, the special circumstances and the vulnerabilities of a refugee or a stateless person, then there has to be some kind of a liberal application with regard to the qualifications stated under CA 473, especially when it comes to lucrative income and
Application requirement.
Yes.
Right.
So with that Carbasi ruling now, the Supreme Court came up by virtue of its power to promulgate rules of procedure under the Constitution, came up through the Special Committee on Facilitated Naturalization for Refugees on the rule on facilitated naturalization of refugees and stateless persons. It was initially chaired by then Chief Justice Diosdado M. Peralta, and the husband of Attorney Gallardo was one of the court attorneys of Chief Justice Peralta. And then eventually, it was when Chief Justice Peralta retired, Supreme Court Associate Justice Ramon Paul Hernando assumed the position as chairperson to date. So through that, the rule on facilitated naturalization for refugees and stateless persons was promulgated in February 15, 2022 under Administrative Matter number 21-07-22-SC.
And I'm happy to note that we at the Supreme Court Public Information Office, Communications Office, are actually publishing to the website of the Supreme Court the petitions for naturalization. There's a requirement under the rule that it has to be published for 3 weeks. And so we're doing that actually for some of the cases. So that's an inexpensive, in fact, no expense at all alternative to an expensive publication in newspapers.
Right. So let me, you mentioned about the salient features of the rule. So some of its salient features are first, of course, expedited procedure. While it was promulgated in February 2022, but if you will look at it, Attorney Mike, it's really aligned with the strategic plan for judicial innovations of the Supreme Court when it comes to efficiency, innovation, and access. Because this rule actually has an innovative feature when we talk about publication in the Supreme Court website. This is the first time that the Supreme Court has introduced that feature, the opportunity in order to reduce the cost of publication, especially for refugees and stateless persons,
Right.
to be able to have the petition published, not just they're given the alternative mode of publication. It could be with the official gazette and in a newspaper of general circulation or in the Supreme Court website. So that in itself, having it published for free, Attorney
Yes.
Mike, in the Supreme Court website would now be more affordable and accessible for refugees and stateless persons. So that's just one of the main features in terms of innovation and efficiency. Then, of course, efficiency, because now there is more or less a 90-day. It would take about 90 days for the entire petition up to decision.
So faster now.
Faster now. And of course, that's it's the 1 year period after the decision is something else. But in terms of the filing of the petition, up to the time that the petition is deemed submitted for decision, would be about 90 days. So that would now be, if you look at the tick box on the SPJI on efficiency. And then you also have interesting features when it comes to children, especially for unaccompanied minors and also for derivative naturalization for the spouse married to the petitioner and including the children, accompanying children, the family. So the provisions of the rule include those provisions in terms of unaccompanied minors and the children of the petitioner, as well as the spouse when it comes to derivative naturalization. And then, of course, with regard to the qualifications, if you will look at also on the qualifications, the accompanying documents. So there are different enumerations which are not totally different from that provided for under CA 473. But then it does not, when it comes to lucrative income, like for instance in the Carbasi case, the court would have to look at the totality of evidence. It does not have to be just by way of proof documents such as submitting income tax returns, but to look at all the other documents as long as the petitioner will not be a public charge or an economic burden to the state, and as long as he is able he has the potential of becoming an asset to the state. So these are things that have to be considered when it comes the totality of evidence as a standard of proof, when it comes to looking at all the qualifications and none of the disqualifications for the petitioner or the asylum seeker seeking judicial naturalization. Another thing also about the salient feature of this rule is that when it comes to the payment of legal and docket fees, there is a reduced cost already of they only have to pay 50%. So that's also one distinctive feature of the rule when it comes to judicial naturalization of refugees and stateless persons. And just recently also under the ULAS, Unified Legal Aid Services, a refugee and a stateless person are now considered as qualified beneficiaries.
Right.
So you can really see how the Supreme Court, through our Chief Justice, Alexander G. Hesmundo, has really, under his leadership, has really tried to implementing the strategic plan for judicial innovations, especially when it comes to access to justice by vulnerable and marginalized sectors. How even refugees now and stateless persons are now part of it. No? It's the inclusivity and accessibility to the administration of justice.
And I'm just curious, Judge Joy, based on your observation, how is this new rule so far affecting the naturalization process of refugees? Has it become faster, or did you have more applications coming in because there's now perception that perhaps it's a lot easier? I mean, I'm just curious how they are perceiving this.
Well, if you will look at, before you can even file for a petition for judicial naturalization, you would have to comply with a 10-year residency.
All right.
10-year, general rule, 10-year residency, and a special 5-year residency in special circumstances.
Right.
So even before, as mentioned by Attorney Iya, before you could file a petition for judicial naturalization, you'll have to make sure that you have complied with that residency requirement. And then you also have to file your declaration of intention, not less than 1 year before the office of the Solicitor General. So these are things about, they're talking about, let's say, at least 10 to 11 years.
11 years, right.
Before you
can even apply this
Yes,
rule. Right.
yes.
Right.
Just to give you an idea of how many cases already have been, how many refugees have availed of naturalization. So far, the figures that we have is that there are about 10 cases already, but 8 of them were under judicial naturalization under CA 473. But under the rule, one has already, the rule was given retroactive application because at the time that his case or his petition was pending, it was still under CA 473, and then the rule on facilitated naturalization was promulgated. So that the liberal procedure under the rule was then applied to his case. And so he's now a naturalized Filipino. Then we have one that's pending now under the rule itself. So I can't go beyond that because of the confidentiality of
I totally
proceedings,
understand.
which is also a salient feature of the rule on facilitated naturalization.
This is where the need to really hasten the whole
Right.
process comes in, as Attorney M mentioned earlier. But beyond the legal requirements that they need to comply with, I'm just curious, Attorney Iya, from your experience, how are refugees actually integrating into local communities, and what sort of challenges are they facing?
Okay, so it's never easy to not have a plan. Usually, you have asylum seekers and refugees arriving at the country of asylum without a concrete plan, right? Because, circumstances compel them to leave immediately without any concrete action plan.
You didn't plan on becoming a refugee.
Exactly. No one plans to become a refugee. So naturally, a person without a plan would encounter some changes, struggles, and challenges in a strange land where they could not speak the language.
Yes.
And even the second language could sometimes be quite difficult for them to understand and speak, which is English. So at the first few months and even years, it's a time for adjustment for asylum seekers and refugees. So their recourse is to come to UNHCR, ask for assistance, because they don't know what options they have while in the country. So you have that challenge. Their psychosocial preparedness is not yet, should I say, optimal, right? But for those who have been living in the Philippines and have acclimatized and have been exposed to the culture and have formed networks within their small circles, these are the refugees that are able to locally integrate. They're able to put up businesses, send their children to schools, sometimes fall in love and be married to the locals. So that's part of their local integration. And I would say those who have persevered and stayed in the country and decided to see what is in store for them have been able to contribute to the society. For example, there's this refugee whose food business thrived during the pandemic, and until now, his business is still very relevant. It's a food industry, and you would oftentimes see him in events, meetings, um, sharing his testimony on how he was able to do it. So it's always important to know that if the country of asylum is willing to give space for people to grow, then they will grow. But if you put them in a place where their potentials are restricted, then you would not see any improvement in their lives. So, what we are seeing right now in terms of the impact of the facilitated naturalization is the increase in interest among refugees to learn more about the procedure, how they would be able to qualify, and addressing the issue on costs. That's also a very important, I think, a strategic step for them. But of course, we have to understand that, again, as I've mentioned, the ultimate goal is for them to be able to return in safety and in dignity in their country of origin, because that's the place where they've been born, where their
That's
families are, and naturalization is sometimes not part of the plan because they're still hopeful that they'd be able to reunite with their families. But for those who have decided and have been able to build families, have
Like
their
Mr.
children
Aboughaula.
here, yes, Philippines is their motherland now. And we are happy that there are refugees who are able to find a second home in this country.
And Judge Joy, as Filipinos, what can we do to support refugees? I mean, is there some convincing that still needs to be done when it comes to the Filipino public, when it comes to attitude towards refugees? How can we as Filipinos support refugees who are going through this process? What can local institutions, perhaps, and other organizations do about it?
Okay. For the judiciary, at least now it's still ongoing. We have trainings for judges, especially for the RTC judges, and hopefully we also intend to go up to the level of the Court of Appeals to train them so that they would have the decision makers would have now a more informed adjudication when it comes to petitions for judicial naturalization, and also when it comes to status determination cases on appeal before the Court of Appeals. Now, as a citizen, like in my case, as an individual, even with the communities, it's really important that we relate to people to show respect, not just respect for asylum seekers, and also try to make them feel part of the community, empowering them to be part of the community. Because eventually, other than, of course, the one of the solutions really to be for them to be able to go home to their country of origin. But then, if they have decided to resettle permanently, or maybe in terms of, let's say, having married let's say a Filipino national, they would eventually would want to settle here permanently and become a citizen. So part of that is really to embrace them as part of the community of people and empower them to be a productive member of the community. And for us here, like here in Moram, Rizal, and Rizal, I know that there are some asylum seekers who live in the Rizal, no? And they have set up, I mean, they're not, let's say, they're not fully heavily dependent on the local government unit. They have their own sari-sari stores to, to sustain themselves. So we try to embrace them as much as possible and make them part of the community. I mean, as I said, it's really compassion and empathy. It's not apathy. As what is happening, in some jurisdictions or in some states, it's really compassion and empathy. And that's something that we have to embrace, that it's not just a matter of a legal responsibility, but one that deep dives into our conscience.
And let me just go back to Attorney Iya, because I know that the UNHCR has been helping a lot of refugees, but maybe a lot of our listeners are not familiar with the work that you do. So what kind of help do you actually provide refugees?
Okay, so Philippines is already doing a fantastic job. Our role actually is found under the 1951 Refugee Convention. We are the guardians of the convention, which means that we have a responsibility to walk hand in hand with the government that hosts refugees to ensure that their laws, their policies, their practices are in alignment with the provisions of the convention. Maybe it's a good opportunity to say that we are advocating to the government in terms of ensuring that the policies are inclusive. There are a number of laws that still are limited to Filipinos. No, it's quite unfortunate because if you have laws that are not inclusive, then you would not be able to meet the agenda of sustainable development goals, which is leaving no one behind. So we continuously hold dialogues with the policy makers to ensure that whatever programs, services that they introduce, do not forget the most vulnerable. And these
Right.
most vulnerable do not have diplomatic protection from their countries of origin. And some of them do not even have nationality to speak of. So I usually explain this in a way that you have your biological children, right? And you have the obligation to support your biological children. But when the Philippines signed the Refugee Convention, Philippines already considered that refugees would be part of their children, adoptive children. And biological children and children who have been adopted should be given the same care by by the parents, and in this case, the parents is the Philippines. So we are also very actively working with the local government units, of course, through the generosity of the Japanese government, in addressing situations of statelessness of Samabajao. Samabajao is one of the population groups that have been identified to be at risk of statelessness because of their generation of non-registration of birth and seafaring itinerant lifestyle. So we go to the grounds, support the provincial and local government units in making birth registration accessible to those who are in the island provinces of Basulta, Basilan, Sulu, and Tawi-Tawi, in certain parts of the Bangsamoro Autonomous Region of Muslim Mindanao. And in addition to that, UNHCR recognizes the importance of technology. So hand in hand with the birth registration processes, we have been able to support select local government units with digitization equipment so that they wouldn't have any problems in retrieving files, just in case there are untoward incidents that would cause damage to the birth certificates. And we realized that birth registration is a problem, a challenge for some of these communities because they live in the coastal area. It's very far from the capital. So we have consulted with the authorities and with the population groups themselves that it's important to bring the services to the people. That's why we have purchased vessels that will be used for services of the provincial government and motor vehicles that would allow them to convert it into like a mobile civil registration facilities. I think it's very similar to the Justice on Wheels concept, but more on the civil registration processes. And Attorney Mike, I'd probably have to mention that for the internally displaced persons, I think it's important to talk about them, is that we have been campaigning for the longest time, for 21 years or even more, for the Congress to pass a law that would protect the rights of internally displaced persons. And talk about durable solutions, because there are still reports of internally displaced persons who have been in protracted displacement
Right.
for years.
And for the benefit of our listeners, we usually refer to them as bakwits, right, in local parlance. All right. So thank you. This has been a very educational discussion. And just Joy, one more final word.
Thank you, Attorney Mike. May I just reiterate the Supreme Court's commitment through the rule on facilitated naturalization for refugees, as well as the training of judges and court personnel on the rule, and also the inclusion of refugees and stateless persons as qualified beneficiaries under the ULAs. This is just but another testament of the Supreme Court's unwavering commitment to building a justice system that is compassionate, inclusive, and accessible to all, and aligned with the Supreme Court's SPJI. So all these initiatives are just the beginning. The trainings will continue, the integration of persons of concern in the court's milestone developments will continue. Though much is still to be done, the path forward is clear. The judiciary remains steadfast in its commitment to actively exert efforts in empowering and protecting persons of concern.
Thank you very much, Judge Joy, Attorney Iya, and Mr. Aboughaula for joining us today. And to our listeners, if you wish to read the full text of the rule, you may search online for AM number 21-07-22-SC or the rule on facilitated naturalization of refugees and stateless persons. Here's Tiff Atendido Beltran, Supreme Court Information Officer, for recent updates about the court.
From the Supreme Court of the Philippines, here's the latest. The Supreme Court has reiterated that a victim's admission of being in a relationship with her abuser does not imply consent to sex. Clear and convincing evidence of consent is still required. In a decision written by Associate Justice Josep Lopez, the SC Second Division affirmed the conviction of accused Jopet Hernandez Toralde for rape of a 14-year-old girl. The SC declared him guilty of rape under the revised penal code, citing that all elements of the crime were present, including the use of threats and intimidation to force sexual intercourse. The SC rejected Duralde's sweetheart defense and affirmed that being in a relationship does not grant the right to force sex. The SC stressed that proving a romantic relationship is not enough. There must be clear evidence of consent. In another case, the SC has ruled that a person's inability to love their spouse that is rooted in a genuine personality disorder may be considered evidence of psychological incapacity and a ground to declare a marriage void. The SC Second Division, through Senior Associate Justice Marvic MVF Leonin, reinstated the earlier ruling of the Regional Trial Court declaring the marriage void from the beginning under Article 36 of the Family Code. The SC ruled in favor of the husband, finding that he had sufficiently proven psychological incapacity. Under Article 36 of the Family Code, a marriage is void if one or both spouses are psychologically unable to fulfill their marital duties, even if the condition becomes evident only after the wedding. Meanwhile, the court has ruled that a land sale made through a verbal, unwritten agreement can be considered valid and binding as long as it has been partly or fully carried out. In a decision written by Associate Justice Samuel Garlan, the SC's Third Division upheld the verbal sale of land between Marcos Batara and his nephew Benedicto Ocampo. The SC found the sale valid even without a written contract since Ocampo had already received the land title, moved into the property, and made improvements on it. The SC added that taking possession of the land and making improvements on it are strong signs that a verbal sale has already taken place. Thus, buyers who are already living on the property can use the verbal agreement as a legal basis for their possession, even if there's no written contract. The Supreme Court has reiterated that a co-owner must give written notice to the other co-owners before selling their share of a property. However, if other co-owners already knew about the sale and failed to exercise their right to buy back the share within 30 days, the written notice is no longer required. In a decision written by Chief Justice Alexander Hismundo, the SC's First Division denied the petition filed by siblings Antonio Azurin Jr. and Rafael Azurin to buy back a parcel of land registered in the name of Carlito Chua. The SC said that under the Civil Code, a co-owner intending to sell their share to a third party must notify the other co-owners in writing about the sale. The SC, however, added that the requirement of written notice can be waived if number 1, unusual circumstances have made the co-owners aware of the sale, and number 2, the co-owners did not take action or were negligent in their right to redeem the property, or what is called laches in law. On June 25, the Supreme Court opened the Philippine Open Government Partnership or OGP Inspirational Gallery at the lobby of the Supreme Court new building. The gallery highlights the milestones of the partnership and the country's progress in the advancement of open government agenda. The installation was originally featured during the 2025 OGP Asia and the Pacific Regional Meeting held in February 2025. As a member of the PHOGP Steering Committee, the SC's role in the achievement of the Philippine OGP 6th National Plan focuses on the advancement of open justice, including initiatives such as the Justice Zones. Led by the Department of Budget and Management in coordination with the Office of Associate Justice Maria Filomena Singh, the gallery is on display until July 9, 2025. Finally, on Friday, Chief Justice Alexander Hismundo administered the oath of office to the newly appointed Deputy Marshals of the Office of the Judiciary Marshals, or OJM, at the SC Bank Session Hall. Sworn into office were retired Major General Joel Napoleon M. Coronel, retired Colonel Randy O. Remonte, and retired former officer in charge of the National Bureau of Investigation's Office of the Director, Eric B. Destor, who will be stationed in Luzon, Visayas, and Mindanao respectively. They will be working under the leadership of Chief Marshal Manuel R. Garlan, who was appointed earlier in March. Under Republic Act No. 11691 or the Judiciary Marshals Act, the OJM shall be primarily responsible for the security, safety, and protection of the members, officials, personnel, and property of the judiciary, including the integrity of the courts and judicial proceedings. You are now up to date with the Philippine Supreme Court. I am Tifat Ndi Beltran, Supreme Court Information Officer.
And that's our podcast this week. Join us again next time for a detailed discussion of select cases decided by the Supreme Court. I'm Attorney Mike Navallo, your Supreme Court Chief Communications Officer. You can catch this podcast on the Supreme Court Public Information Office's accounts on X, Facebook, Instagram, Threads, YouTube, and Spotify. You can also catch previous editions on our website and on Spotify. This podcast episode was produced by the Supreme Court Public Information Office with Attorney Karen Martinez, Jay Rimpilio, and May Sibal as researchers, Don Ryan Balza, Brian Austria, Lawrence Olanyo, Austin Aliscad, and Bea Batong as audio and video editors, and Tyke Flores and Jerome Batumalaki as web editors.